Thank you, Mr. Chief Justice, and may it please the court. The federal officer removal statute authorizes the removal of a civil action commenced against a person acting under a federal officer. As that statutory text suggests, you have to look at the complaint that actually commenced the civil action. That complaint tells you the acts by the defendant that are charged, and then you ask, did the defendant commit those charged acts under a federal officer? That is the straightforward reading of the statute that is reflected in the Watson Court's statement that a defendant may remove to federal court only if, in committing the charged acts, he was acting under a federal officer. And that's what we think makes this an easy case. Petitioners not only abandoned below any argument that they were acting under a federal officer in committing the acts charged in our complaints, but they also told the district courts in italics that they did not need to be acting under a federal officer in committing those acts. And let me be specific about those acts that are actually charged, because we now know, having gone to trial with Chevron down in Point Lahash, that they do not dispute that they dumped billions of gallons of produced water from oil wells directly into our marsh, both before and after 1980. That's why this is such a massive deal for the state of Louisiana. And that's why I think they abandoned any theory that they acted in that misconduct way under a federal officer. All that is why I say we think this is an easy case and the court should affirm. I welcome the court's questions.
How much can you rely on Watson, which is quite different factually? It's a heavily regulated company. Versus, and it was pre-2011. So how much work does Watson actually do for you?
Well, Your Honor, I think Watson's extremely important for us because one thing it does is it catalogs this court's cases going all the way back to Tennessee versus Davis, where the court has said, and this culminated in Watson, the court said all of those precedents, when they're talking about acting under federal authority, they're talking about an agent of the federal government that is acting within the scope of his authority. That's the backdrop against which this court decided Watson. And so I think when you open your analysis section in Watson and you say that a defendant can only remove only if he engages in those charged acts while under a federal officer, I think that's what this court was summarizing, was that entire backdrop of precedents that led up to Watson. Now, I will say, Your Honor, I think the court's decision in Tennessee versus Davis, you look at the Willingham case, what Watson says and reflecting on all those precedents is that when we talk about an agent of the federal government acting within the scope of authority, we're asking about somebody which is basically executing federal duties, except they're doing that on behalf of a federal officer. And that's why we've pointed out in the red brief this fundamental disconnect between this refinery theory, which we could not sue. We could not sue petitioners under our law on this refinery theory because we literally can't grab conduct that is 300 miles away in Port Arthur, Texas at a refinery and say that violates our coastal law. That disconnect on the one hand, whereas the charged conduct that we've outlined in the complaint is literally in the marsh in Plaquemines Parish. This court has never seen, and petitioners have not identified for you, any case where this court has basically mixed and matched the acting under conduct that satisfies prong 1 with whatever the conduct is that satisfies prong 2. Now, my friends on the other side talked a lot about preemption, federal colorable defenses. If I could hit one thing strong this morning, it's this idea that they have a federal colorable defense. Justice Barrett, you asked about whether that's a live issue. I thought to myself, we don't actually have to speculate about whether, how these defenses shake out because we've gone to trial. So if you go down to the public records there at Point Lahash in Plaquemines Parish and you look at the 18-day trial that we had with Chevron, I said, my gosh, I'm gonna read that transcript back, front to back and see how did this narrative of the federal government's bidding in World War II play out and how did the preemption defense play out? And you know what? The jury heard crickets on that because none of that was raised in the Roselle trial. I think that's as dead a giveaway as any, that for all the narrative you see in your briefs in the federal courts about how this is us targeting World War II conduct and everything they did was directed by federal officers, nothing like that in the actual state court proceedings. I think that's the exact same story that would play out in federal court. And that's just the fundamental mismatch in practice. That's the reality, Justice Barrett.